morning, everyone, and thank you for joining us for today's session, where we will be looking at tips and traps when acting for lenders. My name is Stephen Smith, and I'm delighted to be joined, as always, by Ian Quayle and my colleague, Robert Kelly. Good morning to you both.
Good morning.
Morning, Stephen.
Morning, Robert. Before I hand over to Ian, I'd like to go over a few items just so you know how to participate in today's event. So as usual, you'll be listening through your computer's speaker system by default. If you prefer to join over the telephone, you can just select the telephone option in your audio pane, and the dial-in information will be displayed. You will have the opportunity to submit any questions via the text box to Ian. Just simply type your questions into the questions pane of the control panel. You can send in your questions at any time during the presentation, but we will collect these and address them as per usual in a Q&A session at the end of today's presentation. You can also raise your hand. Raising your hand if you're having any difficulties with your IT or technical issues. You can also do it if you would actually like to ask a question over your mic and speakers directly to Ian, myself, or Robert. So please let us know if you want to do that. But if you do have any IT issues, do get in touch with me. Hopefully we will be able to resolve anything. And if not, there will be a recording of the session that will follow in the next 24 to 48 hours. Finally, we've included the notes for today's session in the notes section of the control panel, so you can view that as we go along, as Ian is speaking today. If you're unable to access the notes, please do get in touch with me. Replying to any GoToWebinar communication you've had does come directly to me. So if you would like the notes and you can't get them, please do get in touch and we can send them out. And just I say finally, we've also included some links to our LinkedIn page, our YouTube channel, and Ian's LinkedIn page today. If you would like to watch any of our previous webinars, they are available on the YouTube channel. And if you would like it to link in with Stewart or Ian Quayle and you use that platform, then please feel free to do so. That leaves me to just pass on to Ian for the main part of today's presentation. Thanks, Ian.
Thank you, Stephen, and good morning, everyone. Thanks, Robert, as well, for joining us today. Yeah, today we're going to look at some issues relating to acting for lenders. There's lots and lots of things to talk about. What I've done is just picked one or two items that I think are worthy of consideration, some of which will be sort of a review of things that you know before. One or two things will be hopefully relatively new to you. Again, thank you for Stewart Title for organising today. Robert and Stephen are also very kindly sort of assisting with IT and all that goes with it. And as I say, thank you for everyone coming along. So lots and lots of things to talk about. The first thing I want to talk about really are some issues concerning fraud, property fraud, mortgage fraud, etc. Then what I want to do is to have a look at some issues with regard to conflicts of interest and client confidentiality, just a quick reminder of problems and issues that can arise, and then to talk about some circumstances relating to defects in title and the stance that lenders take and things that lenders are getting jumpy about at the moment. And in addition to that, there are lots of other things that we'll be covering as we explore. A bit of case law to finish. So really, the first thing to do is to ensure some sort of basics with regard to acting for lenders. First point, do make sure that you're up to date with regard to Lenders Handbook and Part 2 instructions. Absolutely essential that when you're dealing with the Halifax Building Society or the Building Society that you're frequently in contact with, that you're alive to the fact that your instructions may have changed recently. And therefore it is important that you or your colleagues keep and are aware of changes, or that you subscribe to the appropriate services that can do that for you. The next thing is to watch out for property fraud. Property fraud that means a lender sustains a hit, because in those circumstances that hit might be transmitted to you with regard to a claim. And also really I want to highlight some of the potential problems associated with mortgage fraud, and the fact that you may be aware, advertently or inadvertently, of some form of problems with regard to mortgage applications that could be indicative of fraud. I want two horror stories to tell you about in that regard. To watch out for the dangers of conflicts of interest and the need to be aware that at the end of the day, the lender is looking at us to ensure that the property that is being secured against their lending is good and marketable. And also ancillary to that, to make sure that we're aware of the fact that there may be issues relating to value that the lender will need to know about as part of our role in acting on their behalf. So as I say, lots and lots of things to talk about. I will be sending Robert and Stephen a copy of the slides. If you want them, you're more than welcome to have copies. And as far as questions are concerned, I'm sure you're familiar now with the system, using the chat facility for questions, which I'll endeavour to answer at the time that we finish the main presentation. So let's have a look at fraud to start with and talk about some issues relating to mortgage fraud and seller identity fraud. First point I note, we've talked about this on a number of occasions. Verification of client identity is not simply a task that is performed at the beginning of the transaction. It is necessary to do that throughout the transaction. And remember, there is a vast amount of case law sitting there that reveals the potential liability a conveyancer for a buyer can incur when acting for a lender, when the buyer or the lender takes a hit with regard to seller identity fraud. So again, just ensure that you are doing that which you are required to do on behalf of the lay client, and be aware that the same duties and obligations apply to the lender as well. It's not enough simply to say, right, I've verified my client's identity at the start of the transaction, I've asked the right questions of the seller's conveyancer at the start of the transaction, I don't have to worry any further than that. There is a constant worry, a constant requirement to be alert to fraud. And that is on connection with this slide and the start of my presentation, some issues with regard to seller identity fraud, buyer identity fraud, in which a lender sustained loss. There is also an awareness and a need to be aware of the risk of mortgage fraud. And again, client identity issues arise. Issues may arise with regard to mortgage applications. A few years ago, I dealt with a horror story where an applicant contended that he was earning a vast salary, but was working as a PE teacher. The reality was that he wasn't receiving a vast salary for his work in school, but had the benefit of an income from a private trust fund. And again, the solicitor, actually on behalf of the borrower, was aware this man was borrowing a significant amount of money on a relatively low income, and notified the lender of that fact. Well, of course, a number of issues arose relating to that. Firstly, an issue with regard to client confidentiality. The appropriate step that should have been taken is that the client should have been asked why the discrepancy between what the income was as a PE teacher and what the income would need to be in order to obtain a mortgage of the size that he was applying for. Had that question been posed, the client could have provided an explanation. And secondly, of course, if you're releasing anything to a lender, it is imperative that you have your client's authority to do so. So issues arose, problems arose as a consequence of a solicitor in that particular context being overzealous with regard to investigation relating to the mortgage application. And Matt, I was just thinking about this this morning. Years and years ago, I was involved on the periphery of a fraud committed by a solicitor that was acquiring property, significant and highly valuable property, using the following method. He would speak to local agents and ask if he could have the keys for a property to go and have a look round it. When he was doing that, he would arrange for a friendly building society valuer to go around and value it on the basis that he was buying the property. He would then perpetrate a fraud by impersonating the registered proprietor and would buy the property on paper with the assistance of the advance from a lender. Now, in those days, there were a number of issues. One, lenders weren't as sophisticated with regard to spotting issues such as the issues that arose in this particular case. Secondly, of course, you would not be able, or your firm wouldn't be able in most circumstances, to act in circumstances where you're acting on behalf of a lender as well. And in addition to that, the lenders would have performed sort of checks with regard to the identity of the sellers that hopefully would have revealed the problem. But I can tell you that that particular chap acquired about 16 properties over a period of 5 years, amassed a fortune as a consequence of what he did, disappeared off to prison when all was revealed, and served 5 years of a 10-year sentence, and went swanning off into the sunset with a whole amount of cash on the basis that in those days, sort of proceeds of crime investigations weren't even heard of. So the important point is be careful about the bigger picture relating to mortgage applications. In addition to that, the last point is significant when acting on behalf of lenders. What does the registered title reveal? Can we see that properties have recently been sold or purchased? Can we reveal, do we have evidence of the purchase price on sale and subsequent purchase? Is there evidence of sort of sub-sales, etc.? All of these things should send alarm bells ringing. So again, the important thing to be aware of is that the lender is our client. As far as our client is concerned, we owe a duty to that client, and there may be information that comes into our file or comes to our knowledge that would warrant notifying the lender of our suspicions. Of course, in those circumstances, it would be necessary to get authority from our client to disclose the information. What is the position if our client says that our lay client says he's not prepared or she's not prepared for us to disclose that information? Well, then the position is we cannot act either for lender or client. But again, just be aware of the potential for problems. And again, it's quite interesting. I was just looking at some research over the weekend, and someone was saying that in essence, because we're working from home, sort of some of our firm's systems and processes aren't as sort of watertight, aren't as efficient as they used to be. Hopefully when we all start returning back to the office, then we'll get back into the good old ways of having people check our suspicions or talking to people face to face about our suspicions. At the moment, there's a lot of isolation in working from home, and therefore a risk that we say, well, yeah, all right, I am suspicious, but the reality is my suspicion is probably unjustified. Let's just proceed with the transaction in any event. My guess is that many a solicitor or conveyancer facing a negligence claim or worse will have sort of rued the day that they didn't take a step back and think about the position or seek advice before deciding that they were happy to proceed. So in the notes, I've given you some detail with regard to what we've said in the past in connection with identity fraud. I've also mentioned in the notes some issues with regard to mortgage fraud. And of course, a number of cases that sort of highlight problems, including Davison Solicitors against Nationwide Building Society, an old case these days, 2012, where for once the courts came to the assistance of solicitors that were acting on behalf of a lender to determine that the solicitors hadn't been negligent nor were they in breach of trust. But then there are other cases, and of course the most famous one, Lloyds Bank against Marketing and Udin, where the Court of Appeal decided that there was a breach of trust arising in connection with the release of mortgage advance without completion, without lawful legal completion taking place when a sale was perpetrated by a fraudster impersonating the registered proprietor. So again, be aware of those issues and be aware of the point that I mentioned in the notes just above the bottom of page 4 about the SDT deciding that it was professional misconduct not to verify client identity checks with regard to a conveyancing transaction. This was a remortgage where problems arose as a consequence of an assumption being made that the client's identity was all well and good when in fact it wasn't. So the interesting thing there is that the Law Society and SRA and tribunal determined, even though there was no personal gain involved, as an experienced conveyancing practitioner, the respondents' failure to undertake some of the most fundamental and basic steps that solicitors are legally and professionally obliged to do constituted serious professional misconduct. So we've got to be careful about ensuring that we're doing the simple things well with regard to identity fraud at the start of the transaction, during the life of the transaction, and aware of the potential for mortgage fraud. At one stage, the amount of fraud in connection with conveyancing transactions was staggering. I think 5% of the English property market was determined to have some form of fraudulent element. The vast majority of that fraudulent element was mortgage fraud, fraud with regard to mortgage applications, but still a fairly staggering figure. I haven't seen, that was about 4 or 5 years ago, I haven't seen recent figures with regard to the percentage of the market that is tainted with fraud. But all I can say quite safely is that it will be out there. And as I've mentioned too in the past, the sort of lockdown and problems associated with lockdown will obtain a charter for fraudsters to perpetrate more fraud, be it identity fraud, mortgage fraud, and the like. So remember, identity fraud is an issue. Lockdowns given fraudsters added opportunities. Watch fraud throughout the transaction, and watch because you owe a duty to the lender to report to the lender anything that will impact on title, anything that would impact on valuation. And remember, of course, you can't just simply disclose issues to a lender where you haven't got authority from the lay client to make those disclosures. More on that in a moment or two. The next thing I want to talk about is undue influence. And the reason I want to talk about undue influence is that undue influence can lead to lenders sustaining liability or loss on the basis of constructive notice. So if you are aware of undue influence on the part of co-owners in connection with an acquisition, and that acquisition is being funded by a mortgage, then there is a potential problem with regard to the lender being liable in connection with loss that's sustained by the victim of the undue influence, liable on the basis of an inability to repossess a property or liable for financial loss. So always do consider undue influence. And here I'm not just thinking about the obvious, children bringing elderly parents who are selling their home and going to live in some form of caravan or chalet to try and circumvent problems with regard to home bills, etc., to a situation where you're acting on behalf of co-owners in connection with an acquisition. So is the client acting on his or her own free will? Do you suspect improper pressure? So if there is improper pressure, that of itself will be undue influence. Or is there such a relationship that it's safe to assume a rebuttable presumption that undue influence exists? In all of these situations, we must be careful. Remember, actual undue influence is overt acts of improper pressure, coercion, or indirect pressure, which is beyond ordinary or commercial pressure. And undue influence requires this pre-existing relationship, where there is then a transaction that follows, which calls for some form of logical or rational explanation relating to it. Important to be aware of the risk of undue influence, important to be aware that that could generate professional responsibility and liability as between the victim and your firm, but also puts the lender in the firing line as well. What I've done in the notes is gone back to our friends at Ettridge, Royal Bank of Scotland against Ettridge, 2001 decision. Now it's amazing how time flies, and just highlighting some of the points from that case. Details at page 6 of the notes. In all loan situations, and this is interesting in that Ettridge was looking at borrower and guarantor, but sort of widening the picture a little, the view was that there was always a risk of a lender being put on inquiry that there might be undue influence, no matter what the relationship between the parties. Lender is always put an inquiry with regard to the risk of undue influence where a transaction involves an undue degree of risk. We'll talk about such transactions in a moment or two. A lender doesn't need to have knowledge that was a relationship giving rise to the presumption of undue influence for undue influence to be in existence and for it to ensure that a transaction is voidable. Lender will have constructive notice of any impropriety which is found to exist, unless it can establish it's taken reasonable steps to ensure that the surety or parties to the transaction understood the nature and effect of the transaction. That's where you come in. Sufficient but not essential for a representative of the lender to explain the transaction and material risk to parties. So again, as far as that is concerned, although Ettridge was sort of highlighting the potential vulnerability or exposure to a guarantor, and here's an important point this morning, I would never act on behalf of a guarantor that wasn't deriving some form of financial benefit from that which they were guaranteeing. Why? Because in those circumstances, no matter what the circumstances, your advice ought to be that the client should not be providing a guarantee. So I don't care if it's son and daughter that's buying a property and the client is being asked to guarantee the loan, or some form of commercial transaction, again, where a guarantee is required. A reasonable conveyancer advising the guarantor is bound to say, unless there is some form of benefit that you are deriving, you shouldn't be entering into the guarantee, on the basis that no matter what the guarantee provides for, your vulnerability is likely to be extensive. The upside doesn't exist, and the downside is scary, is really the way I would put it to a client. In addition to that, I've referred to the Law Society guidance on undue influence, which arose after Ettridge, to be honest with you, but again, it's quite interesting. There's a requirement that we ensure that the client's wishes are met, and that if a client wants to instruct you to act, there isn't a conflict of interest, that the client has sufficient information about the transaction and necessary experience and understanding to be able to provide advice and to understand that advice, provide advice in a non-technical manner, make sure that advice that is given is recorded, and ensure that consent is obtained from the client to confirm in writing to the fact that advice has been given. Clarify the position, therefore, we've got to understand that clients in a lending situation, the borrower is in essence vulnerable, and that the client should have an explanation as to the nature of the charge, the consequence of the charge, and the position as to what happens where the client defaults. We should be explaining the nature and practical effect of the legal charge, the risk and consequences of default, and the purpose of the loan or the facility. Now, this item at the bottom of page 6 is something that I want to major on for a moment or two. A lot of firms will simply explain to a client that a legal charge simply secures that the money that the lender is providing on the property that the client is acquiring. Some firms do not then provide additional information about the risks and consequences of default, nor do they provide assistance as to what clients can do when they encounter difficulties. It is important, in my view, to explain to the client the bigger picture. The extent of that explanation is a matter for you, but certainly if I'm your client, you should be telling me about the significance of the mortgage document that I'm signing, the relationship that I have with the lender, the risk that is exposed to me as a consequence of that relationship breaking down due to my default relating to the mortgage. In other words, my inability to pay the mortgage as and when it falls due, and the sort of safety nets that are out there in circumstances where difficulties arise. So I think those points at the bottom of page 6 are significant and are worth just checking your letters or emails to clients to make sure you're explaining the bigger picture. So one of the things that the SRA and Law Society have been looking at with regard to the conveyancing process, in that instead of sort of just focusing in on the transaction and the transactional issues, to look at the bigger picture with regard to home ownership. And sometimes, because of the sort of concerns that we have with regard to the risk or vulnerability of a negligence claim being brought, we focus in on the detail with regard to the transaction without stepping back and looking at the bigger picture as well. And all I'm trying to do here is say, following Ettridge, following the Law Society's guidance on undue influence, we've got to be careful to make sure that we're alert to it, but flowing on from that, we've got to make sure that clients generally are aware of what a mortgage is, what a mortgage does, and the risks associated with it. The next point that I want to make is an issue concerning conflicts of interest and lenders. Generally speaking, an institutional lender and a borrower will have substantially the same common interest in the transaction, namely the acquisition of a good and marketable title. It is also important to note that where we're acting for co-owners, as I've mentioned to you in the past, co-owners are not a singular client. So where we're acting for co-owners and a lender, we're in essence acting on behalf of 3 clients, and hopefully all have a substantial common interest in the transaction, but they may not for different reasons. Certainly from a lending perspective, a lender is looking at a property to ensure it is good and marketable as far as the title is concerned, but also that it's an appropriate security for monies that are being loaned. As far as that issue is concerned, as I say, the client may not be too concerned about the issue of security, nor indeed about the quality of the title that's being offered. They're just simply blinded by the fact this is the home of their dreams and this is the property that they wish to acquire. The important point here is, remember, each client is separate, each client has a different stance or different position, and the common interest may dissipate during the life of the transaction. So remember the basic issues with regard to clients. Make sure that we're explaining to clients risks and issues. Make sure that we've got informed consent to proceed. Make sure that it's reasonable for us to act, and that we are always contemplating the benefit of acquisition as opposed to the risk. And those 4 points, those 4 basic points, apply just as much to a lender as they do to a lay client. Now, we're lucky in that we don't have to explain the normal risks and issues associated with lending. We do have to, however, advise about risk and issue relating to title. And the problem that we have, and the problem that is impossible to resolve, is this. Lenders, institutional lenders, rely on conveyancers to confirm that a title is good and marketable, and that they will be registered with the first legal charge on the title after completion upon registration of the transfer. Now, a number of points really that I think are significant with regard to that point. What is the position if there's a defect in the title? Are we under an obligation to explain to the client, the lender client, what the risk is? Answer, yes. Are we obliged to explain whether that risk means that the title is not good and marketable? The answer is yes. And then we should be asking our client lender whether they wish to proceed. In other words, we should be asking for them to confirm that they are happy to consent to provide the loan, notwithstanding the disclosure that we've made to them. The problem that we encounter, and the problem that conveyancers have encountered from the year dot, is the fact that a lender won't commit. A lender, in essence, will say, if there's an issue or if there's a problem, well, what's your view? Or will be guided by you. In other words, what a lender is saying, although not saying it directly, is it's down to you. And we're all right, because if there is a problem or you get it wrong, you've got a professional indemnity policy that we can call upon and utilize for any loss that we sustain. There are pinch points in a transaction where the call has to be made. Are we happy? Can we complete a certificate of title confirming this title is good and marketable? Or are we in a situation where we're going to upset our lay client by saying to the lender, this property is not good and marketable, not good security for your loan? The problem there is, I would always maintain that the position should be that this isn't just a case of a decision being taken relating to this transaction. The decision that's taken to proceed can have ramifications and implications for you and the firm. And therefore, always consider the position of the lender first and foremost. You might have a client bleating or screaming at you that they want to proceed, and a client will be absolutely fuming when you're telling them that you've got to advise the lender this property is not good or adequate security for their purposes. But there are times where that call has to be made, and there's times where you have to be firm. What I would say from a practical perspective with regard to that is, before I reach that sort of pinch point or that point in time where some pretty ugly decisions have to be made, I would speak to a colleague and just say, hey, look, this is the position. this is what I think. I don't think this title is good and marketable. I don't think the lender should be lending on it, and we should be advising the lender not to proceed. Remember, I think there's always sort of what I class as a sniff test. You sort of have a look at it at first blush and say to yourself, well, is this right or not? And generally speaking, that initial view is the view that you should stick with. But I would always get a second opinion as to what the position is relating to the lender and their vulnerability and exposure. Unfortunately, other than one or two of the small building societies, I have rarely encountered one of the larger institutional lenders that have been able to take a view or been prepared to take a view where a question is being posed. Here's the title, you know, it's a good leasehold title. I'm not satisfied that we'll be able to upgrade it. My view is that it is not a good and marketable title, but what do you think? I've never had a lender come back and say, no, we're happy, or no, we're not. Invariably, they bounce it straight back and say, well, what's your view? You know, that's why you're being instructed in this transaction. And the point that I'm laboring is just be careful where that is the case. Remember, with regard to confidentiality, that confidentiality is applicable across the board. Remember that as far as that issue is concerned, the position should be that we need to be aware of client confidentiality throughout the transaction. Therefore, if we are in a situation where we want to disclose something to a lender, we need our client's authority to do so. Remember the Law Society's practice note of 2011, 8th of December 2011, which I refer at page 9 of the notes. If a mortgage application includes a general consent by the borrower to inspection of the conveyancing file by the lender, then the lender is entitled to see the file. But other than that, a lender and borrower are entitled to see those documents to which parties have a common interest. And the practice note highlights what those documents will be. Anything else that is on file technically belongs to the client, and therefore you need client authority to disclose it to anyone else. At item 4, I talk about title problems. And the first issue, of course, is that we're looking at a good and marketable title in order to sign off a certificate of title to an institutional lender. There are a number of things really that I think are significant in that regard. The first is, of course, that when we are looking at a good and marketable title, we are also looking at the ability to register a first legal charge in the name of the institutional lender as part of our instructions. And the first thing I mention is that there is an impediment to that, courtesy of the land registry and the early completion procedure. I've given you details concerning that at 9, 10, and 11 of the notes. In short, the early completion procedure is not frequently encountered, mainly because institutional lenders will put a restriction on the title that will mean that the early completion procedure cannot apply. But where it does apply, you are left with a position at completion and upon registration of the registered proprietor that the buyer becomes the proprietor, the seller's name is removed from the title, the buyer's title is registered as a first legal charge, but the seller's charge remains as a second charge on the title, theoretically allowing the seller's lender to potentially repossess at some date in the future, assuming the seller defaults with regard to the mortgage. You can imagine a doomsday scenario where the seller's conveyancer attempts to redeem the mortgage of the seller's charge, but doesn't send sufficient monies, or there's a problem or a dispute with regard to the redemption figure. The seller's charge as a second charge will remain on the title and will create vulnerability with regard to the buyer's first charge on the basis that the seller's lender could theoretically repossess the title on the basis of seller default. Now, all right, you might think, well, we're getting into the realms of sort of an academic argument rather than a practical one. I have seen a situation where the early completion procedure did create a difficulty for the buyer's conveyancer because the seller's charge as a second charge on the title couldn't be removed. for a significant amount of time due to a problem with regard to a dispute between the seller and the seller's lender as to the amount to redeem. The next point that I mentioned that can cause problems with regard to lenders are issues with regard to restrictions on registered titles. And again, I've mentioned to you this in the past, it is imperative with regard to a restriction that's on a registered title that you identify the restriction is capable of being complied with. If it isn't, then the restriction should be disapplied, cancelled or modified. We've discussed the process of doing that in the past. The next point to note that I think is significant, again with regard to title, is the issue, again, that I've encountered from time to time and encountered just recently, relating to the position concerning estate rent charges. Again, a lot of detail in the notes on page 13 onwards. The problem with an estate rent charge is that the Rent Charges Act 1977 doesn't apply. Some practitioners think, because I've had emails on this point just recently, that the 77 Act means that estate rent charges are going to disappear. Well, they're not. The 77 Act does not apply to estate rent charges. Secondly, estate rent charges are becoming more commonplace because rather than creating a new leasehold scheme with regard to housing development, developers are looking at freehold schemes because of the unpopularity of leaseholds, and are using estate rent charges as a replacement to service charge. Unfortunately, estate rent charges do not have the same statutory protection that is associated with service charge, and therefore there's very little opportunity to challenge an estate rent charge or to determine what an estate rent charge actually is or liability for an estate rent charge via legislation. It is therefore imperative that if you are dealing with a property with an estate rent charge, that you ensure that the document that creates the estate rent charge has some form of control or some form of mechanism that affords protection for the rent payer, for the buyer of the property. The reason that lenders are so jumpy about estate rent charges is the fact that if an estate rent charge isn't paid, then the owner of the rent charge is entitled to various methods of enforcing liability, one of which includes the creation of a lease. Lenders don't like that, and therefore, whenever you're encountering a problem or a property with an estate rent charge, I would be reporting the matter to the lender and asking the lender to determine whether or not they wish to proceed. Where the estate rent charge has some form of mechanism for determining the extent of the charge, some form of ability to challenge the charge, then it may be possible to advise the client, lender, that the estate rent charge does not impact on their security or on valuation issues. But again, something I haven't mentioned so far, I wouldn't be giving an opinion as to whether an estate rent charge impacts on valuation. That's a job for the lender's valuer. And that applies across the board with regard to a defect in title or indeed anything else. You're not in a position to say whether that will impact on the title or value. So you are able to say what it would impact on title, but not on value. You may be able to express a view that the value of property may be less as a consequence of a title issue or problem determined, but it is for a valuer or a surveyor to confirm the position and to attempt to quantify that vulnerability. The next point, again, I've seen this just recently. I've seen an institutional lender refuse to lend on the basis that the property being acquired is composed of a number of registered titles. Now, why would a lender be concerned about this? Well, the concern arises again from a point that I've made to you in the past. Land registry title plans are notoriously unreliable. We may be buying a property that is composed of 3 registered titles. We can't guarantee, courtesy of a land registry title plan, that those 3 titles abut one another. There may be slivers of unregistered land sitting between the registered titles. That's what lenders are bothered about. Now, what can we do? Well, if we have the time and the inclination, we could ask the seller to consolidate the titles to create one title, which would solve the problem. we could investigate the position to determine whether or not there are any slivers of unregistered land sitting between the respective plots that are being acquired. Other options that may be available to us would include taking out a sort of defective title insurance policy with regard to problems associated with plans, associated with defective plans. But you can understand why lenders are a little jumpy. The problem isn't unresolvable, and the problem isn't a vast problem where titles are separated, but the house, this real security for the lender, is composed of one title. So if we have, the Meadows 21 Acacia Gardens, and as far as the Meadows is concerned, it is divided into 3 titles: the house, plot A, which is part of the garden, plot B, which is also part of the garden. From a lender's perspective, as long as the title to the house, the title to the land on which the house is situated, is one title, and that is sufficient security for the amount of loan, the lender should be fairly comfortable. But I've seen some lenders that immediately are talking about more than one title relating to a residential property, being very concerned about the position at best, refusing to lend at worst. The next thing I've mentioned again is something that I've just encountered this year, but I have seen a similar difficulty arising in the past. And what happens here is you are buying land that's subject to overage. The overage won't bite in connection with the current transaction. So it's not a question of your buyer client being required to pay overage. The problem is that there is overage on the title. The vast majority of lenders will not lend where there is such overage. Just mere mention of the word overage immediately gets them closing their books and refusing to lend. Some will, but some, if not all, will insist, if they are prepared to lend, that the overage provision is postponed over the legal charge. So the legal charge takes priority over the overage. Again, with regard to this, it is important to understand and appreciate that where there is overage that will bite in the future, the lender needs to be aware of it and needs to determine whether they're prepared to lend or not. The important point there is there's some good news. Most lenders won't ask for your opinion about the overage clause. They just simply won't lend. So we're not left with that dilemma of, do we say to the lender, no, you don't lend on it, and then incur the wrath of the lay client? Invariably, the lender will take the decision out of our hands and decide themselves. And then, of course, we've got the age-old problems with regard to leasehold titles and problems with regard to ground rent. Just had a discussion with someone Friday of last week. I repeat my advice that if you are looking at a ground rent review provision, and the ground rent review means that it is impossible to determine in 2021 what the ground rent will be in 2031, then we must warn our client, lay client and lender about their vulnerability. So just because ground rent is to be reviewed and calculated as a percentage of retail price index, inflation rates, the value, the market value of the property concerned, does not give me any real comfort, because I don't know what the market value of that property will be in 10 years' time. I don't know what the inflation rate will be or the retail price index will be. And therefore, how on earth can I advise a client or indeed a lender that it will be safe to proceed? What I'm looking for with regard to ground rent review is some form of fixed increase. So I can say to my client, in 2031, the ground rent will increase by 10%. In those circumstances, everyone knows what the ground rent will be and can take a view as to whether they wish to proceed or not. I mentioned in the notes a number of points relating to ground rent. And again, some of this at the bottom of page, top of page 18, bottom of page 18, top of page 19, is sort of something that we can look at in sort of more general terms. Remember, you've got no duty to advise on the commerciality of a transaction. That applies to the lay client and applies to the lender as well. With an institutional lender, we're fortunate in that an institutional lender can't impose any additional obligations on us with regard to our duties that are owed to the lender, courtesy of the agreed form of certificate of title. So the sort of risk analysis that we might have to undertake for a lay client does not apply to a lending client. And that applies with regard to ground rent. It applies to other provisions within the lease. On the topic of other provisions in the lease, watch out for lenders on leasehold property and the remaining term. I remember when the vast majority of lenders would be willing to accept a leasehold property for mortgage purposes where the term remaining was the length of the mortgage term plus 25 years. These days, you're seeing a whole raft of different positions with regard to lenders. Remember, my starting point is that I'd be warning a lay client about buying a property where the term remaining was less than 82 years. Check your mortgage instructions, your lender's instructions, to see what they're willing to accept. Watch forfeiture clauses. I am seeing some leases, new leases, where forfeiture is obtainable where a borrower becomes insolvent. Clearly, that will be inappropriate where a lender is lending on the property, and therefore such a forfeiture clause should be challenged. And watch, again, in some leases, I'm seeing landlords break clauses that are permissible where a landlord is unable to reinstate a building where fire or damage has occurred. Again, some lenders will now accept such a provision in a lease, but they will impose conditions, namely conditions with regard to an equitable distribution of insurance monies and site value. Again, it's important to understand that a lot of these things will impact on value as well as quality of title. So the point that I made earlier about asking the lender to get their valuer to check the implications of the provision would apply just as much with regard to issues associated with term remaining as onerous provisions within the lease itself. As far as lending and due diligence is concerned, there are a number of points that I want to make. In essence, there can be issues that are identifiable via due diligence that will impact on valuation. Again, there could be information in TA forms, information relating to searches and adverse entries therein, or information relating to cladding that could impact on valuation. It is therefore important to identify not just whether or not title is good and marketable, but also whether there is anything else that's revealed as part of the conveyancing process that will impact on valuation, as well as, or in addition to, issues associated with title. So, for example, if a TA form reveals that there's a dispute with neighbours that's ongoing, well, again, if a lender repossesses and sells, that dispute could well have an impact on valuation or an inability to sell. If there's an issue with regard to a central heating system that has some form of defect or is in a state of repair, again, that could cause issues. And again, it may be that the lender is able to deal with those issues by way of retention, etc. But nonetheless, there could be issues that are within your knowledge, courtesy of due diligence, that would warrant or require additional investigation, or a valuer revaluing or assessing a valuation as a consequence. I've given you in the notes some issues with regard to cladding, courtesy of some RICS guidance that's been published for valuers on the 8th of March 2021, basically looking at EWS1s again. The reason I mention it here is that there's an important point to emphasize. An EWS1, as the RICS emphasised, is not a sort of fire safety certificate. It isn't a confirmation that there isn't a risk or the extent of the risk. The purpose of an EWS1 is to ensure that a valuation can be provided for a mortgage or remortgage, where a property features an external wall cladding system. So again, whilst it may have fire safety implications, the essence is that this document is a valuation document. I mentioned in the notes that the position is that as of now, sellers can request that their building owner or managing agent commission an EWS assessment. Remember, the clients themselves can't. And remember that it may be possible for the local authority or the fire and rescue service to intervene where a request has been made for an EWS 1 that has fallen on stony ground with regard to the building owner. I mentioned that there is a problem at the moment with regard to EWS 1s being produced by unqualified professionals or even fraudsters. And therefore, whilst consideration of the EWS 1 is a matter for the lender's valuer, it is important for you, if an EWS 1 comes across your path, just to check whether there's any sign of that would raise suspicion with regard to the production of the document. Again, I've given you details in the notes in that regard. There is now a requirement for an EWS assessment every 5 years. And the idea here is that the continuing obligation for the production of a report is to look at renovation and adaptation work that's done relating to the building. Again, we've looked at this issue in the past when dealing with fire safety and cladding issues. I've just added some sort of more information in the notes that are relevant to lenders and those advising lenders. Bottom of 23, you may have come across a situation where a high-rise flat is being sold and a valuer has valued it at a nil value. Nil valuations are, generally speaking, arising where a valuer is unable to provide a value at the moment in time, generally speaking, because he's got insufficient information to generate any form of valuation. Often a nil valuation will signal that lenders require additional information rather than a property being unsellable. But again, all the time you are guided by valuation surveying advice. Why are lenders asking for EWS 1 forms for properties below 18 metres? Well, again, some lenders are still asking for this, and the reason was that government advice was given in 2020, January 2020, generally speaking, meaning that all residential buildings require EWS 1s. Most lenders now should appreciate that that is not the case, but again, just be careful with regard to your instructions. The next thing I want to mention are certificates of title or reports on title. So just go on. Yeah. When you're dealing with an institutional lender, it's safe to say that the certificate of title will be approved by the Law Society, and therefore you are able to act. What does it do? In essence, it confirms that there are no legal problems with regard to the property. There is a good and marketable title. Remember that a good and marketable title may have gaps that can be plugged courtesy of a defective title insurance policy. The certificate confirms who is going to own the property, who's going to be the registered proprietor upon completion and registration of disposition. Will also confirm that the lender will receive a first legal charge in connection with their security. The important point with regard to a certificate is that it is, if approved by the Law Society, reduces the risk of a conflict of interest. It follows that where you're acting on behalf of a private lender, you've got to be so careful about whether you can act at all. And if you are acting, what you're going to say to the lender with regard to your investigations. My rule would be I would never act on behalf of a private lender in connection with a residential purchase. It would always be appropriate for that lender to take independent legal advice. Where you're acting for an institutional lender, you have the protection of the Law Society's intervention with regard to the information that you're producing to the lender and your duty to that lender. Two words of caution that I mentioned in the notes that I think are significant. The risk of conflict of interest is high, too high in my view, when acting on behalf of a non-institutional lender with regard to a mortgage. And again, if you are acting on behalf of a lender and borrower, it is important to understand what the certificate of title is doing and what your duty is to the lender. The next point that I've done is giving you some case law I just want you to have a look at before we start taking some questions. Edwards against Bank of Scotland. The reason I mention this case is that you had a forged legal mortgage, which caused problems, allowing a lender to have an equitable mortgage over the property, but not a legal mortgage. Again, the question I'm often asked, do I have to see a client signing a mortgage deed? Well, the answer to the question is no, you don't, but it is good practice to ensure that the document is signed in your presence. Of course, that's not feasible these days. Where the document is being signed elsewhere, imperative that you check that the signature appears to be the signature of your client, and you ask the client to confirm any information that is requested where you have any doubts. Hughes Holland against BPE solicitors is an interesting case, again, that I've given you in the notes. The reason that I mentioned this case is that we had a situation where there were solicitors sued successfully in negligence by a lender on the basis that the solicitors should have explained to the lender what the funds that were being released were to be applied for, and should have explained to the lender the circumstances with regard to the borrower. Quite an interesting case, again, full details in the notes. I have also mentioned two cases, Skipton Building Society against Clayton, and also a case of Woolwich Building Society against Dickman. The reason I've mentioned both of these cases is because one of the things that scares the living daylights out of me at the moment are schemes relating to equity release and sale and leaseback schemes. Don't know if you saw today's conveyancer or if you've seen the report on BBC Radio Wales in connection with a company that was offering sort of emergency purchases of property for people that were in distress and about to be repossessed. But in essence, what you've got is a firm of solicitors, I think from the Birmingham area, in difficulty on the basis that they were acting on behalf of sellers of property who were selling to this company and also were connected to the company itself. And I mean, there's one situation where a property was worth £165,000 and was bought for £65,000 by a company called Speedy Property. And again, the allegations against the solicitors concerned relate to conflict of interest, failing to give advice to sellers who were vulnerable and who were being offered very uneconomic transactions with regard to the purchase price. So Skipton and Woolwich Building Society, Clayton and Dickman highlight the problem with regard to sale and leaseback transactions, with Dickman in particular highlighting the need, if you're acting on behalf of a party to such a transaction, to check the position with regard to the tenancy that is being offered. I am conscious of time, and I am conscious of the fact that we need to spend a little bit of time looking at questions, and I'm happy, Steve, if possible, to take any questions that are available via the chat facility. Before we do that, and whilst Steve is just loading up whatever questions are to be loaded up, just a reminder that Stewart Title have a raft of product. And as far as the defective title product is concerned, it's right to say that that product can benefit and protect your clients, but it can also protect your firm with regard to potential risk or vulnerability to negligence claims from the client itself and also from lenders. Robert, anything you want to add to that point?
No, Ian, I mean, you're quite right. We do have them, and it is an area, I think, where insurers have been quite proactive in the last few years, as things like the ground rents and the estate rent charges have become a problem. And yes, we have them there. We're always happy to talk to people, and they do deal with lender protection there, which is important. subject always to the some lenders, as you'll know, are rather more difficult to deal with and won't accept insurance, but we're always happy to put forward products and to talk to people about it.
Thanks, Robert. That's great. Steve, question time?
Yes, excuse me. Thank you, Ian, and thank you, Robert. I've had a number of questions already, so thank you to everyone that's submitted them. Usually I'd ask people if they want to submit questions at this point. We might not get round to actually answering them all, but just as a reminder, if you would like us to come back to you on any questions, you can submit a question through the text panel on your control panel there. And if we don't get to it in this session, then we will come back to you in the next few days if you let us know what your question is. But if I kick off straight away with the questions, Ian, we have a question and a comment from Daniel. Daniel asks, at what point during the transaction and on what triggers should one identify throughout the life of the transaction? Should one identify the client, sorry, throughout the life of the transaction? So I'll repeat that actually. At what points during the transaction and on what triggers should one identify the client throughout the life of the transaction?
Got it. Yeah, great. Well, obviously, at the start of instruction, if you're acting for a seller, you want the seller to verify ID, either old-fashioned sort of paper method or electronic verification. And remember what we said in the past about checking address for service at the land registry against client's contact details. Thereafter, through the life of the transaction, if a client is signing documents, I would be checking signature against previous signatures or other signatures that are held on file. And to answer the question, this is a tricky one. If there's anything that appears remotely suspicious about the client during the life of the transaction, maintain a watching brief. So there might be something that is insignificant in isolation, but collectively with other conduct or other things, again, would warrant further investigation. So, for example, if I'm your client and I'm selling a property, and my address for service at the land registry is not the correspondence address that I've given you, alarm bells would ring. If I'm asked questions by the buyer's conveyancer with regard to additional inquiries, and the question is the sort of question that an owner of the property would be able to answer immediately, and I can't, and I say, oh, hang on a minute, I need to talk to someone about that, or I need to check the position, again, that would be suspicious. And it might be that one issue in isolation is suspicious but doesn't warrant any further investigation. Say those two things would warrant or justify having a look and perhaps having a chat with a colleague about what further steps could be made to verify ID. So I can't give you a checklist, Steve, of points during the life of the transaction to say be careful. But I would say whenever you're looking at client signatures, I would check them. I would, again, during the life of the transaction, just be aware that information that is asked for can't be provided, or there's a reluctance or hesitancy to provide it. Again, alarm bells would ring. Or just the demeanor of the client. You know, again, the Law Society suggests this. You know, if I've got 7 email addresses and I'm constantly changing mobile telephone numbers, that's not normal, and that would be potentially suspicious. So it's being aware of the entire picture during the entirety of the transaction. So I don't really help, but that's what the law is, and that's what you're required to do.
Yeah, no, thank you. I think that's very helpful, and thank you, Daniel, for that question. We have a couple of questions with regards to guarantees and guarantors as well.
Yeah.
So Robert McNally asks, Ian, often a separate firm is asked to act for a guarantor to satisfy the requirement for a separate legal advice. How onerous is that role for the separate firm?
Very, very onerous in my view, because unless I make the point again, unless I as a guarantor am deriving some form of financial benefit from the transaction, you'd have to ask the guarantor, you'd have to tell the guarantor or advise the guarantor not to proceed. So if my daughter was buying a property and I'm asked to guarantee her mortgage with, you know, one of these family mortgages, right? The question is, what financial benefit do I derive from that transaction? Answer, nothing. Now, yes, as a father, it might be the decent thing to do, it might be the right and honourable thing to do, but from a purely commercial perspective, you can't say it makes sense to act as a guarantor in that context, and that's the point that I'm making. So my view would be, if a client is coming to my firm and saying, will you act for me because I've been asked to guarantee a loan that my daughter is obtaining to enable her to get on the housing ladder, my view would be, I can't act, okay? Don't want to act on the basis that what I'm going to be saying to you is you shouldn't be doing this. Now, I know some firms that are prepared to act, and that's fine. All I would say, if you were prepared to act, I would be making sure that I'd be drilling into the client. You're not deriving any financial benefit out of this. The upside is zero. The downside is potentially significant, and therefore there may be a motive and a justification that's honourable, but from a commercial perspective, what you're doing makes no sense whatsoever. I'd be as blunt and as brutal as that, Steve.
Excellent, thanks, Ian. I think following on actually quite nicely from that, I don't know if you'll be able to answer this, Ian, per se, but Daniel asks, I often find that guarantees provide no commercial benefit for the guarantor, which is exactly what you're saying there. What then is the way forward where the guarantor can in some way provide this assistance, brackets, as opposed to simply refusing to act?
Yeah, well, that's exactly the point. You would have a very firm email or letter to the client saying, we've advised you not to proceed. You've instructed us in connection with the transaction. You're not deriving any form of financial betterment as a consequence of what you're doing, but you're asking us to proceed on the basis of some form of moral or honourable obligation you feel to the borrower, something of that nature. But I think you just set out the position, if you are acting, so that the client is blatantly aware of their risk and vulnerability. And with regard to guarantees, there are a number of points. Firstly, I would never allow a client to sign an unlimited guarantee of unlimited duration. We'd always want some form of provision that would enable your client to escape. Now, I know some lenders won't allow that, but again, I'd be advising my client that if you are to sign a guarantee, it should have some form of cap and should be for some form of finite period, something of that nature. But again, what you're doing is just protecting yourself, because I know your clients will do it for members of the family, etc. The reason for doing it is perfectly honourable and reasonable and decent. But again, the thing that worries me is we're all well and good now in April 2021. Property market crashes in the next 3 or 4 years. Daughter that we've guaranteed loses a job, loses the property, repossessed, lender sustained loss, and our friendly father or mother that's sort of guaranteed the debt gets a nasty letter on their via email or on their desk via the post saying from a lender that we want £35,000 from you, or else. It's that situation that worries me, Steve.
Yeah, no, absolutely, and thank you. And thank you, Daniel, for that question. On the subject of rent charges, Ian, Laura asks, are there automatic statutory rights for beneficiaries of rent charges, or do they have to be expressly mentioned in the deed setting out the rent charge? And Laura follows on with that with an example saying, I have a client purchasing at the moment and property is subject to an estate rent charge. The transfer setting out the rent charge contains no rights of forfeiture.
Yeah. The situation is that you don't need express provision in the document that creates the rent charge for those rights to exist. What you are looking for in the source document is provision that imposes some form of reasonableness on the owner of the rent charge and some form of dispute resolution process again within it. Even that isn't going to satisfy most lenders, but it might satisfy some. But to answer the question from, was it Laura, you don't need express provision with regard to forfeiture or the creation of a new lease for the owner of the estate rent charge to impose such a regime on the rent payer.
Perfect, thank you, Ian. We'll just, I'm conscious of the time, so we'll just take 3 more questions we have here. There are people that have sent in a few questions, so I just want to make sure that everyone that has sent a question gets at least one answered. So just quickly, Lawrence asks, on a leasehold purchase with mortgage involvement, if I'm made aware the management company hasn't complied with the terms of the block policy endorsement for qualified builder surveyor to inspect that roof annually, how should I proceed if the management company hasn't reported this to the insurer and confirmed the policy still stands in full effect? I mean, Robert may want to come in on that as well. But.
Yeah, the position there is that if there is a management company, then you are obliged to notify a lender if the management company is not properly run. So a failure by the management company to comply with obligations that are imposed on it relating to insurance would be something that would be reporting to a lender.
Absolutely, yeah. So I mean, the follow-on from that actually that Lawrence asked there is, should I report any apparent breach of the endorsement to the lender client?
Yeah.
So, yeah, I think that's what you're saying. Lawrence, hopefully that answers your question there. Mark asks, if acting for a buyer and the seller has agreed to the most recent Law Society completion by post, is it counterproductive to ask questions on the seller identity unless there is something glaringly obvious?
Yes, yeah, absolutely. Yeah.
You
shouldn't, again, I refer, is it Mark?
That's right, yes. Yeah.
I refer Mark to, there's a great paper written by a barrister called Nick Taggart called Who Do You Think You're Kidding? That's available on the Property Litigation Association website. If Mark hasn't seen it, if he drops me a note, I'll send him a copy of it. But he highlights the point that the more questions you're asking as a buyer of the seller client's identity, the greater vulnerability you have, because the seller's conveyancer is not going to answer or provide the information that you require. So you've raised it as an issue, but not got a satisfactory response. So, Nick Taggart, who's, as I say, a barrister on the point, says that you create more vulnerability in raising the question than not raising the question in the first place.
Perfect. Thank you. Thanks, Ian. Thank you, Mark, for that. Just one final question, then we have a couple of comments as well beyond that. So is it not the duty of the mortgage advisor to check the pay slips of the borrower and inform the lender about the same borrower's capacity to pay the mortgage based on this income?
Yeah, it is. But the problem we've got is estate agents, mortgage advisors, etc., are not treated by the courts in the same way that conveyancers and solicitors are. And therefore, whatever they do is fine. Whatever they don't do may or may not lead to civil or indeed criminal liability. The point is, what are you aware of? And if you're aware of anything, then you have a duty to the lender to disclose the existence of what you found. So yeah, 100%. Mortgage advisors, etc., should be, acting as supervisors with regard to the mortgage application process, and should be behaving reasonably and legally. But if you become aware of anything, then again, your obligations to the lender override whatever's occurred in the past.
Perfect. Thanks, Ian. And thanks, I think it's Vaishnavi. Thank you. Vaishnavi, thank you for that question. So yeah, and just finally, Harriet just makes a point. She says, I had Santander come back and say that as long as I could confirm that the value was not affected, then they were happy to proceed. Obviously, I can't do that. So clients walked away from the purchase. Brackets, it was an excuse they were looking for.
Yeah. Again, Harriet makes the point, Steve, that's so important. A lot of these things are valuation issues. And it's very unfair for a lender basically say, well, what do you think? We're not valuers. The lender is appointing a valuer. That valuer should be giving advice about the problem. We should simply be a post box to say to the valuer, there's the issue. How does that impact on valuation?
Perfect. Thank you. Thanks, Ian. And thanks, Harriet, for making that point as well.
Yeah.
Ian, I'm going to wrap it up there unless there was anything you wanted to add at the end.
No, thanks. It's really interesting stuff, this. You spend a lot of time looking at, because there are so many issues. But the thing that really galls me is the fact that, most lenders are not prepared to take the burden away from their conveyancers and say, right, we'll take a view. Yeah, we're happy. Our decision, you've told us what the position is. We, as a building society, are happy to lend. Thanks for telling us about it. Not, well, it's not for us to say. what do you say, Mr. Solicitor or Mr. Conveyancer? And just by the way, if you get it wrong, we're happy because you've got a professional indemnity policy that we can call upon. I think that's very unfair, but lenders are not geared up. Their legal departments are not geared up to do the type of decision making that really I want them to make, and that's the problem.
Absolutely. No, thank you, Ian. And thank you to everyone for attending today's webinar. Apologies to people that we didn't get to the second question or any further questions they had. We will try to respond to these in the next couple of days if we can.
Yeah.
Just quickly, as I mentioned in the intro, we have included links in the chat to our YouTube channel where you can see the recording of this webinar after tomorrow, and also recordings of our previous webinars. You can also link in with us through our LinkedIn page and Ian's LinkedIn page, which is also in our chat section. If you do have any other questions, please contact Ian or myself or Robert, and we'll be happy to come back to you. Once you leave today's webinar, you will receive an automated message, as per usual, from GoToWebinar. If you respond to this email, the replies do come directly to me, so I can send any questions or feedback on to Ian or Robert. You will also receive a separate email from Robert in the next day or so, which will contain the slides and notes to today's session. I noticed actually more than ever actually today, a few people had some issues accessing the notes, so please do not hesitate to contact me if you do want to have the notes for the session. I'd be happy to provide them. So I just even say on behalf of Stewart Title and in Quayle, thank you so much for joining us again today, and have a great rest of your day. Thanks and goodbye.